Hello, fellow classmates Liz and Stephen. My name is Elizabeth, and I'm going to be presenting the United Kingdom's Equality Act of 2010. According to equalities.gov.uk, the Equality Act of 2010 is an act to make provision to require ministers of the Crown and others, when making strategic decisions about the exercise of their functions, to have regard to the desirability of reducing socio-economic inequalities, to reform and harmonize equality law and restate the greater part of the enactments relating to discrimination and harassment related to certain personal characteristics, to enable certain employers to be required to publish information about the differences in pay between male and female employees, to prohibit victimization in certain circumstances, to require the exercise of certain functions to be with regard to the need to eliminate discrimination and other prohibited conduct, to enable duties to be imposed in relation to the exercise of public procurement functions, to increase equality of opportunity, to amend the law relating to rights and responsibilities in family relationships and for connected purposes. Equal rights for all have been desired for many years. In terms of the development of the Equality Act of 2010, the first related act was the Race Relations Act, which was created in 1965. However, since this time, other personal characteristics that needed protection arose, so new acts were implemented, such as the 1970 Equal Pay Act, 1975 Sex Discrimination Act, 1976 Race Relations Act, 1995 Disability Discrimination Act, 2003 Employment Equality Regulations pertaining to religion or belief, and a separate one pertaining to sexual orientation, 2006 Employment Equality of Age, 2006 Equality Act Part 2, and the 2007 Act pertaining to sexual orientation. The Equality Act of 2010 is a disability-embedded policy that also protects the following characteristics: age, gender reassignment, marriage and civil partnership, race, pregnancy and maternity, sex, religion or belief, and sexual orientation. This act extends situations in which an individual is protected against harassment, discrimination, and/or victimization because of a protected characteristic mentioned above. It requires specific public bodies to think about socioeconomic disadvantage when deciding how to exercise certain functions. Protect individuals against being discriminated against by granting individuals the opportunity to make a claim if they are wrongfully discriminated against because of two or more applicable protected characteristics, and grants employers the opportunity to be proactive in fixing or minimizing a disadvantage from resulting due to a protected character, to name a few. Since this class is centered around disability policy, the remainder of this video lecture will focus primarily on disability, which is directly addressed in Section 6.1, Disability as Discrimination in Section 25.2, and the disabled person in Section 6.2 and 6.4 of the Equality Act of 2010. In Section 6.1, disability is defined as the physical or mental impairment, and the impairment has a substantial and long-term adverse effect on the person's ability to carry out normal day-to-day activities. In Section 6.1, disability is defined, as I just told you. Throughout the rest of this presentation, I'm going to focus on Section 60 of the Equality Act of 2010, which addresses inquiries about disability and health. This states that a person to whom an application for work is made must not ask about the health of the applicant before offering work to the applicant, or where a person is not in a position to offer work to the applicant. Before including the applicant in a pool of applicants from whom a person intends to select a person to whom to offer work. However, this does not apply to a question that a person asks if it is necessary to. 1. Establish whether the applicant will be able to comply with the requirement to undergo an assessment, or establishing whether a duty to make reasonable adjustments is or will be imposed to a person in relation to the applicant in connection with the requirement to undergo assessment. 2. Establishing whether the applicant will be able to carry out a function that is intrinsic to the work concerned. 3. Monitoring diverse in the range of persons applying to that person for work. 4. Taking action to which Section 158 would apply if references in that section to persons who share a protected characteristic where references to disabled persons or persons who are not disabled, and the reference to the characteristic where a reference to disability. Or, finally, 5, if a person applies in relation to work, a requirement to have a particular disability, establishing whether the applicant has that disability. Essentially, what the above information is saying is that employers are no longer allowed to inquire about pre-employment health questions to potential employees or applicants. This is a legitimate theory because the Equality Act of 2010's definition of disability fits into it and is protected by Section 60. I think this is morally and ethically sound because individuals' disabilities could be completely irrelevant to the position they are applying for. So, why would the employer need to know? This embodies the consequentialism model because by the employer not asking about the individual's irrelevant disability, he and the employer may have a beneficial consequence of hiring a good employee and gaining a decent job. For example, if an individual had a disability that prohibited them from standing more than 2 hours at a time, and they were applying for a position as a secretary, the fact that they cannot stand for long periods of time is irrelevant because the job entails sitting for extended periods of time and answering phones. The environment does not limit this individual in this situation. In this instance, it is a barrier-free environment. However, if the employer probed about this information and found out that they could not stand for long periods of time, the individual may develop an internal bias and hire someone with the same exact qualifications or less that can stand for long periods of time, even though the job does not require this in the least, because they may be seen as more capable in the employer's eyes, even though this information does not pertain to the position. This external policy is beneficial to disabled people because it protects their rights. If they are just as capable as the next person to perform a task, why should they have to reveal a disability that would not affect their job performance? If a job requires something like climbing scaffolds, an employer should frame the question as to whether or not they can complete the task like this. This job requires climbing scaffolding multiple times a day. Are you equipped to successfully and thoroughly complete this task? As opposed to saying, do you have any disabilities that I should know about? Which may put an unnecessary label on that individual without exploring their full potential. For safety reasons, however, I do believe employers should review job requirements and ask if tasks can be successfully completed, leaving disability out of the question entirely. The consequences of asking inappropriate pre-employment questions will be held against the employer if there is proof that unjust discrimination, according to the Equality Act of 2010, took place. The Equality and Human Rights Commission may investigate and enforce punishment against the offender. Only necessary pre-employment health questions should be asked to ensure the applicant's safety. I will leave you with one question to ponder regarding society's rules and regulations. When an individual is giving a professional speech, they are expected to dress in professional attire and be in a professional environment. However, you did not know I was giving you this presentation from my comfort of my own bathtub until now. Is my presentation still legitimate, and why?